Now, if I can turn to this morning's panel discussion, we are really lucky to be joined by 4 experts in their field who are going to be talking about a really diverse set of topics. So first of all, we're going to hear from Alison Hunter. And Alison is a partner at Wesley Gryk and co-chair of the ILPA European Working Group. She's recommended in Band 1 of Chambers and Partners and is described as being an expert in European free movement matters with an impressive track record in such. Now, Alison is going to talk about the areas she foresees causing problems in the future for EU citizens and their families living and working here, including the immediate future, obtaining settled status, and then finally naturalisation. Second, we're going to hear from Neena Acharya, and I must apologise at this point. Neena's surname was misspelt in the agenda. It should be Acharya. Huge apologies to Neena for that. And Neena is a solicitor from Coram Children's Legal Centre, working in the immigration team on a wide range of legal aid immigration cases, with particular emphasis on children, young people and families, including asylum seekers and victims of trafficking. And she's going to look in particular at the impact on children after Brexit in the immigration context. Third, we're going to hear from Natasha Hotson. And Natasha heads up the UK immigration practice at Clinton's, and she advises on all aspects of UK immigration and nationality applications. She represents a broad spectrum of clients spanning industry sectors, including media, entertainment companies, financial services, SMEs, startup and entrepreneurs. And she consults regularly with the Home Office policymaker, liaising with industry representative bodies to inform their discussions about government policy. And she will be talking about the considerations for businesses regarding hiring EEA nationals from the 1st of January 2021. And finally, we'll be hearing from Professor Parosha Chandran, who's a barrister at One Pump Court. She has 23 years experience of representing victims of human rights abuses, trafficking and modern slavery. She is a senior legal advisor to the British Parliament Modern Slavery Project, in which she advises Commonwealth states on the necessary amendments to their laws. And she's also a professor of practice in modern slavery at King's College, where she teaches her own master's course. She will be talking about some of the potential legal implications of Brexit on trafficking and modern slavery cases. If I can start now by handing straight over to Alison. And if I could ask Alison, thank you, and I will turn my camera off. Thank you.
Excellent, good morning. I was asked to talk about some of the problems that I foresee in the future. And of course, that is such a wide topic that I had a wonderful choice of things to look at. So what I've done is I've just chosen some of the subjects that I think are going to be of most interest to practitioners, particularly solicitors, who need to be warning their clients now of what might happen in the future. So if we cast our minds back to maybe 2017, 2018, when the European settlement scheme was a twinkle in the eye of some immigration minister at the time, we were given to believe at the time that it was going to be a fairly generous solution to the problem of what we were going to do with EEA nationals who are here and their family members. And to be fair, cynics like me have to admit that the Home Office has managed to roll out a relatively good system that's working for the majority of people. That's not for everybody by a long shot, but for the bulk of European nationals and their family members who are here, I think it does work. It took a practical approach. It looked at residents rather than an exercise of treaty rights. It didn't enforce the issue or force the issue about comprehensive sickness insurance. And rather belatedly and under a lot of pressure, of course, the fee was dropped. But what I want to spend my minutes looking at is some of the problems that I see and the restrictions on this generosity as we go forward with all the new legislation that has just come out and the changes to Appendix EU, and to flag up some issues that I think practitioners are going to be litigating in the future, but also for just to be warning clients about how they're going to need to behave in the future. The first piece of legislation I want to look at is the Citizens' Rights Application Deadline and Temporary Protection EU Exit Regs 2020. These are now commonly being called the Grace Period Regs. They come into force on the 1st of January, and the basic scheme is that new EEA arrivals will no longer benefit from free movement law, but that existing EEA residents and their family will keep the same rights and can register under the EU settlement scheme until the 30th of June 2021. So I think in practice this has two things that will hit practitioners and advisors very quickly. The first is that people, new EEA arrivals, and particularly their family members coming here as visitors, will not be able to switch into the European settlement scheme. Obviously, they will also not be able to do a number of things that they already do, like come here and work immediately. But I think it's the switching provision that is actually going to cause quite a lot of problems. They will be needing to use the Appendix EU family permit. The second thing is that this idea of exercising a treaty right has crept back in. The only people who can benefit from the provisions of the grace period regs and who can register by June 2021 are those who are so-called relevant persons, and they are defined as those who do not yet have leave under the settlement scheme and were lawfully resident at the end of the transition period. In other words, those who are not exercising treaty rights before the end of 2020 and are awaiting a decision or who are yet to apply under the European settlement scheme will not be legally in the United Kingdom during that grace period. And this seems very much contrary to the way the European settlement scheme has been set up, could cause some significant problems in terms of benefits and other things for some clients. Now, I'd now like to move on to a topic that I think many of you will already know about, and this is again this issue about lawful residence, and it's been picked up again in naturalisation. So as a new European citizen, you're welcomed here, you're allowed to come here, stay here under the European settlement scheme, and then what you would hope really from an immigration scheme is that it leads to what I would call full integration in a way, and people naturalising. But in September, the government brought out new guidance in terms of naturalisation, and it appears that the Naturalisation Directorate does not really talk to the European Directorate. As many of you will know, two requirements to naturalise are the lawful resident requirement and a good character requirement. The guidance has been updated to warn caseworkers that somebody with settled status might not have had lawful residence because they might not have been exercising treaty rights. So when a caseworker comes to look to see if somebody was lawfully resident for the 5-year period or the 3-year period if married to a British citizen, they need to look beyond whether the person has just got settled status and look behind that and see whether they were exercising a treaty right. The Home Office gives the example, of course, of comprehensive sickness insurance, and reminds us that self-sufficient people and students were not necessarily exercising treaty rights if they didn't have comprehensive sickness insurance. This again, though, is not only in this part of the guidance, but it's slipped into the good character guidance, which is in some ways even more worrying because that slips back all the way for 10 years. So if you haven't been lawfully resident for 10 years, or you haven't been complying with immigration requirements for 10 years, then you might not be able to naturalise. I should add here that caseworkers have got discretion to overlook the fact that somebody didn't hold, for example, comprehensive sickness insurance, but there's no guidance about how they're going to use that discretion. And I should add, just as a footnote, that the European Commission has finally started infringement proceedings against the United Kingdom on the issue of comprehensive sickness insurance. As you may know, the Commission believes that the National Health Service should be considered to be comprehensive sickness insurance. And so they've now decided to take this up with the government and have written the first letter to the Home Office to ask for an explanation. My final point, which I think is going to cause a number of serious problems in the future, is a slightly different one. And it's the one that I call the cliff edge scenario. It's one that we picked up at ILPA very early on and have been in dialogue with the Home Office about, but have not really been able to push the boundaries at all about them changing anything. And it's the issue of when you move from pre-settled status to settled status. So as you will know, when you move to settled status, an applicant has to look backwards and show that they've been in the United Kingdom continuously for 5 years. In other words, they mustn't have been out of the UK for more than 6 months in a year, or if there's an exception, if there's been a very good reason, such as childbirth, you can be out for up to a year. Previously, as people who've done permanent residence applications will know, the Home Office used to look at the date that you applied, go back in year steps and take the 6 months in those years. So you could actually be a little bit flexible, and you could move when you made the application and then cut the years up as you wanted. The Home Office now appears to have gone backwards on this and be taking a more stringent approach, more in line with what they do for other indefinite leave to remain categories. And a caseworker can choose any day within the 5-year period, look back a year, and the applicant can't have been outside the United Kingdom for more than 180 days. So it's being taken on a rolling basis. The problem with this is that clients who come to the end of their pre-settled status and are looking back over those 5 years are left in a very difficult position if they have broken their continuity of residence, because they are, unlike in many other immigration categories, they're not going to be able to extend in that category just because they've been out for too long. They're going to need to find another category, because you cannot move on to settled status if you've broken that continuity. So the fact that they can be out for 2 years and not lose their pre-settled status is of no relevance whatsoever if you can't then move on to settled status. So what I foresee is a whole load of people in 3, 4, 5 years' time coming to that point and having to switch into the domestic legislation that we have in place at the moment and trying to scramble to find a category into which they fit. As you can imagine, I foresee a lot of problems for individuals there, and a lot of reliance on issues like family life to be able to remain here in the future. I appreciate that these have been 3 rather arbitrary examples of problematic areas that I can foresee, and I think there are plenty more that I could have touched on. I think what is going to be extremely difficult, and what has been underestimated, is how much we take free movement rights for granted. People come here for a day, they come in to sing an opera because the Royal Opera House doesn't have their singer for the night, so we call somebody up in Munich and in they come, they fly in, they work. We are not used to Europeans having to consider whether they're visitors, whether they can switch into categories here. And we have, with rail services and flights being so cheap, it's become relatively easy for people to do this. So we're not only having to change an immigration system, we're having to change a mindset. And that, in some ways, is much more difficult. It's something that we've got, as advisors, have got to be very aware of when talking to our clients. I have to say that looking back in 2016, when I was lamenting that my practice of European free movement law was over and that I would never, ever have a European client again, a barrister said to me, "Alison, you will be litigating this stuff until you retire." And I fear he's right. With the complexity of the legislation that's just come out, with the new Appendix EU, we will be doing this law for a long, long time. Thank you.
Thank you, Alison, for that really useful highlighting of some of the problems and thoughts going forward. If I can now turn to Neena, as I said, who's going to be talking about the particular impact upon children.
Hello. Firstly, I'm going to thank my colleagues in the Migrant Children's Project who conduct a lot of the EU law casework for the information that I'm going to talk about. The legal nitty-gritty of the impact of Brexit on children is actually being covered in the later sessions. So I'm going to focus on some of the current issues facing children and young people and why this raises concern from 11 p.m. on 31st December onwards. So the first issue that has been identified is that we don't know how many people who are eligible to apply have applied, and the information we have about children and young people seems to have lost quite a few children. So we know that the government previously estimated from ONS data that there are around 5,000 children in care and 4,000 care leavers who would need to regularise their status. But in November 2020, the Home Office published a survey conducted with local authorities, which found that they have only identified 3,220 children, and we're not sure why the numbers are so low. And as of 30th October 2020, less than half of those children and care leavers eligible to apply have submitted applications, and less than a third have actually achieved their settled or pre-settled status. So we know that the guidance places mandatory obligations on local authorities and health and social care trusts to support looked after children and care leavers, and they also have signposting duties towards Section 20 supported children and children in alternative forms of care. But there are many groups of children who may be in a special guardianship order or informal or private fostering arrangements, or Section 17 supported families who are not getting any advice at all. And so the danger is that these people, who are some of the most vulnerable, are not going to apply. So why are so few children for whom the local authority do have a duty applying? The reasons seem to vary. So some local authorities have made systemic changes, but a lot seem to be relying on individual social workers contacting organisations or making the application. And then there's also a lack of understanding by the local authority about the types of identity documents that the Home Office will accept. So if there's no passport, they're not making the application, whereas the Home Office have indicated that they will accept alternative evidence of nationality. The other thing is that local authorities don't know that legal aid is available for separated children and that ECF is available for children over 18. So the second issue is documentation itself. So proof of relationship can be a practical obstacle to a child obtaining the passport they need to apply. And in the case, for example, where one parent is an EEA citizen and the child is being raised by a sole carer who's a third country national, embassies and consulates often require the participation of both parents or a birth certificate and can refuse to provide confirmation in writing of someone's nationality. So the Home Office has at times suggested to people making these applications that the client could use the family court to obtain a declaration of parentage. This poses difficulties first in finding a solicitor who is willing to do that because legal aid isn't always available. Secondly, it can take at least 6 months to obtain an order, and also family court judges don't like being asked to make orders to facilitate immigration applications. The issue of documentation is compounded for children in the secure estate. So there have been COVID-related issues for gaining access because not all young offenders institutes will facilitate telephone appointments, and not all of them have welfare officers that are proactive in helping the children obtain the evidence that they need. I was going to talk briefly about the guidance on deportation, but because we have limited time, I'm gonna, and it is being covered later on, I'm not going to mention it other than to say that there are sort of tactical and strategic difficulties, because the guidance says that where an applicant is aged 10 or over, although you don't have to disclose your criminal convictions unless you're 18 or over, but they will check the police national computer anyway. There are also practical issues with working with children who are in the secure estate, which is that getting them to download the app to scan their passport and their photo. Yeah, so that's another issue. The issue of Zambrano, very briefly, the guidance says that an application must be refused if a person has either limited leave to enter or remain, or could make one under Appendix FM or Article 8, because the Home Office have said that the Zambrano principle can't be regarded as a backdoor route to residence. I'm raising this because we have a few clients who've applied for settled status without having a derivative residence card already issued under the regs. And there are A, massive delays, and B, we're just starting to get refusals in and have no idea when the appeals are likely to be listed. We've talked a lot about Zambrano because it is a possible opportunity for primary carers of British citizen children to obtain settled status, you know, very quickly rather than the very punishing 10-year route. But we have very few people who are brave enough to go down that road, particularly because they know it will, they will be forced to go to appeal. So Alison has already said the exit regulations only protect those who do not yet have leave but were lawfully resident with regs previously, or they had permanent residence. So we already can see from the statistics that there are going to be a lot of eligible children or young people who haven't applied, who haven't got a decision, and then can't establish rights under the regulations because they don't have access to the EA national parent, who may or may not have been exercising treaty rights. They may be vulnerable, and so they can't, they're care leavers who can't work themselves, or and what's going to happen is that your right to work, rent and claim benefits depends on your right to reside as at 31st December 2020. So the next issue is what happens from the 1st of July 2021 to all of these people who haven't applied. And we know that there are going to be lots of people, vulnerable people, who are going to slip through the net. So the Home Office have said that people can make a late application. We don't have the guidance on what reasonable grounds are for applying late, but they've said that the guidance will be generous and there won't be a set time period in some cases, and applicants will be able to challenge decisions. So children are included in the class of people who will be able to make a late application. The other knock-on impacts of the hostile environment for someone who can't also establish treaty rights and hasn't got pre-settled or settled status are that pre-settled status, that they won't have a right to reside for benefits purposes necessarily. Even if they have pre-settled status, that's not necessarily a right to reside for benefits purposes unless you also have a right under the EEA regulations. So again, this can cause real difficulties for care leavers, people seeking to obtain excuse me, student finance because they wish to enter higher education, also may struggle to demonstrate ordinary residence. There may be issues if you have a short period of being undocumented because you didn't apply by the 30th of June. Finally, I'm sorry if I'm whizzing through this. The family reunification has its own session this afternoon. I'll just point out that the Red Cross have a very useful table on their website of who can apply and benefit under Dublin and who can apply under the immigration rules post 31st of December. Now, and I want to end by just talking about current case where we are challenging the refusal of a take charge request of a child in Greece seeking to join his uncle here in the UK. And there's a very much of a hardening of the Home Office policy and a feeling that they are just waiting for the clock to tick to the end of the year. So this child was on Lesbos, and the Greek lawyers submitted a DNA test results, but they were submitted late, outside the time limit for requesting a reconsideration. The Home Office refused to consider the DNA test evidence, so we lodged a judicial review. The Home Office lodged an acknowledgement of service containing no defence, but offering to settle the case if we withdraw, if the Home Office would then ask the sending state to send a new 17.2 take charge request rather than withdraw the initial decision. So if we'd withdrawn, if we'd settled on that basis and withdrawn, there's no way of knowing whether the Greek authorities would make a 17.2 request before the end of the year. And in 2021, it will no longer be possible to submit such a request. We have been granted permission in this case, but I understand from Safe Passage that this is a current practice on the part of the Home Office to say that this is a remedy that the requesting authorities can make a new take charge request. I think that's all I wanted to say. Just that we have massive concerns that the vulnerable people who are eligible to benefit from the EUSS are not going to be able to do so. And I hope that has come across. Thank you for listening.
Thank you very much for setting out some of those extremely serious concerns in relation to the potential consequences upon children. If I can now turn to Natasha.
Okay, so I'm going to take you through some of the considerations that I guess you might have and employers might have about employing EEA nationals and Swiss nationals after the end of the transition period. I think one of the sort of first things for us to get to grips with as practitioners is how we can help employers, because I think they're feeling quite overwhelmed. Not only are we leaving Europe at the end of the transition period, but there's a new immigration system that has come in, and there are some sort of tricky dilemmas in terms of European nationals. Also, the way the new guidance is framed, just from our perspective as reps, it is sort of an example, again, of the Home Office, in a sense, perhaps trying to cut the rep out a bit. It's not that it shouldn't be simplified to make it easier to understand, but they very explicitly say things like, they've sort of reminded sponsors, you can advise Tier 2 migrants and Tier 5 migrants on their individual applications as per the 1999 Act, which wasn't in the previous guidance. And they've sort of put in a lot of detail about how they might use the system. Nonetheless, it's still over 200 pages of guidance in 3 different parts. But I think that they perhaps won't get their wish with employers necessarily handling all of this, because they are feeling somewhat overwhelmed, given the situation of lots of redundancies, unfortunately, that they're having to deal with. So I think we can sort of certainly come in useful with helping them look at their employee population and the types of jobs for which they would generally recruit European nationals. And one of the first things in that guidance that is going to be tricky, I think, is the definition of settled worker. So they explain a settled worker doesn't need sponsorship, but they define a settled worker as someone who, is an EEA national or eligible family member who's arrived in the UK before 11 p.m. on the 31st of December and who has had their application for pre-settled or settled status submitted and granted by the 30th of June 2021. So you might get instances where, of course, an application hasn't been granted by that date. Then what is the employer supposed to do? It would perhaps entail having to, put someone under the domestic immigration system and things like that. And there's an added difficulty for employers in that they're not allowed to ask applicants if they've made an application for pre-settled or settled status and to provide evidence of that. They're supposed to just be satisfied by the passport or national ID card. But this is really sort of unsatisfactory, where you have employees that have perhaps don't actually know, haven't put the application in. But you can be telling employers and your clients it's fine to tell people about the settlement scheme and to even ask them if they want some help with the application. And it's always worth talking to employment counsel as well about what is or is not sort of permissible. So, for example, they may say, look, it's fine to inquire about the date of entry of somebody you wish to hire, to try and gauge, as much as you can without, whether or not they're going to, fall under the sort of EU settlement scheme, or whether you're going to need to sponsor them. We would hope more guidance does come out from the Home Office to clarify these points. And I think they're being chased by practitioners, but it's just worth flagging that the definition of settled worker, isn't particularly, may not be particularly helpful. And then we come to looking at the types of jobs and the sort of vacancies. And obviously employers aren't going to have to contend with the labour market test. And actually today at about 9:15, they put out a new Appendix D, because we were all sort of waiting for that, weren't we? I still can't see the new immigration rules or the Appendix SW, but anyway, which is supposed to come out today. But the new Appendix D, which sort of refers to the labour market test, but it says where it's not required, you don't need anything on file apart from showing, how the person meets the skill set for the job. So a detailed job description and any sort of qualifications if requested in advertising. But one thing one thing is the genuine vacancy requirement in the sponsorship guidance. Which does sort of imply that companies have to, that there is a business need to hire somebody, and that the vacancy is genuine and that it's not disproportionate in terms of the size of the organisation. So I would say that really, although there isn't a labour market test required, you would be advising employers that they've got to that there would have to be something on file in terms of the process they've carried out, because surely this could be raised on audit and it could be a compliance point if they're trying to argue that a vacancy isn't genuine or there wasn't a sufficient business need to hire in that person. So that's certainly one of the things that I think is going to come up. And the other thing that the guidance does with European nationals, the pattern has been, according to all the statistics surveys, that they're in some of the sort of more administrative roles or some of the lower skilled roles. And we know that there isn't provision for lower skilled jobs such as, waitressing and hotel receptionists. And maybe that will come in under Tier 5 youth mobility, but only if another country is prepared to make an agreement with us. But you've got a lot of roles that are falling into, and as there's no appendix skilled worker, it's all still in that further policy statement on the Home Office website that was updated last on the 4th of August and originally published in July. But if we go by that document, you'll see a lot of examples of jobs in tables sort of 27 and 28 that are eligible without any sort of job description attached to them. And with that, they then sort of refer sponsors in the guidance very explicitly to the ONS, to the Office of National Statistics website to help, and they very explicitly say in the guidance to the employer, it is your responsibility to identify the appropriate SOC code. We will not help you. That's the exact wording. But if you try to, we, for example, had an administrator job, a sales administrator or a sales coordinator. Now, as it happens, in the eligible jobs in table 28, there is a sales administrator job, but without a job description. And there are a load of other admin jobs, such as office supervisor, any financial admin, credit controller, that are not sufficiently skilled. So without a job description, how do you do it? I tell you, the ONS website is particularly unhelpful because it just bans a lot of jobs at sort of GCSE level, but actually they happen to be eligible jobs. So it's not really very specific at all. It's not helpful. But one thing that is, that you can use is a sponsor guidance makes clear, and under the definition of genuine vacancy, that if you have the job duties must not be predominantly lower skilled. So I had this administrator role for sale, a lot of it was supporting a sales team, but there were other tasks like stock control and really basic admin. But fortunately, because, you get the job description and you can discover what predominantly the person is doing. So even if there are a few lower skilled bits to it, as long as it, the rest of it meets the sort of job title and they're supporting a sales team, for example, then that would fit. But I think these things are going to be quite confusing for employers when it comes to their EEA population, and indeed to some Tier 5 youth mobility scheme migrants that are going to switch. I can see that, this being problematic. And again, despite the Home Office perhaps wanting to reduce the role of representatives, I think we would certainly come in useful when trying to work out how an employer can assess the jobs. And when they've got this population of European national employees and they're thinking they would have European nationals perhaps filling similar roles, then I think representatives come in handy at being able to map out those roles properly for them, particularly where there's no job description provided in the guidance. So that was one thing. And the other thing I think is about, the flexibility of the routes. I think there is, as everyone acknowledges, a huge gap for self-employment. Frontier Worker comes out on the 10th of December. So those that are eligible, but that's obviously not for sort of new arrivals, but those who are eligible might want to frantically do that because they would be able to benefit, from a Frontier permit, for, which would last 2 years and give them the right to be self-employed in the UK. We know that another route would be introduced, a sort of self-sponsored route. Now, in the further detailed statement, in which the same document that includes all the sort of SOC codes, they say that the route would be carefully monitored and capped. So it does imply that that's going to be limited. Self-employment is permitted under skilled worker in the same way as it is under Tier 2. And still a lot of employers, again, don't know about self-employment and that it is allowed as long as there's a sort of contract between the company, between the company and the individual, and the company is prepared to maintain their sponsor obligation. So it's going to be, again, important to remind people of that. But obviously the limitation a lot of self-employed people will find is that they want to work for more than one company. And the supplementary and secondary employment provisions just haven't really changed. So that is very limited. So I can see that is going to create problems. And that perhaps the self-employment highly skilled route is going to have to be a bit more flexible than the government would like in order to accommodate European nationals who want to come over here and be self-employed. So obviously the numbers of self-employed people, it's constantly growing in the UK. So that is certainly something that I think has been inadequately dealt with in the guidance. And again, individuals I think are gonna have a real difficulty in sort of coming in under self-employment unless they are in the sort of theatre industry, but then the creative visa is rather temporary, only for an initial period of 12 months, maximum of 24. And again, people like charity workers, if they don't meet the sort of thresholds for skilled worker, the Tier 5 charity worker visa is incredibly limited because it's for people who are, doing, sort of almost like it's really a job that fulfills the purpose of the charity, but it can't be, you know, they can't do any fundraising or any sort of actual work on the side. So that is a very difficult one to fulfill, and there have been lots of instances of entry clearance refusals for those types of applications. So it's going to be quite challenging, I think, for European nationals, you know, in certain sectors to sort of come into the UK and continue working. And the fact there are no lower skilled jobs, I think, is also going to be problematic. I guess a lot of this remains to be seen in all the various consultations. But one of the other things, well, which is disappointing, is part-time working. So again, the new guidance, you know, doesn't allow part-time working to be sort of taken into consideration. They're going to base salary thresholds on actual earnings. So again, there must be lots of European nationals who are working on a part-time basis here, but the new system isn't going to help them. And I fear there won't be much appetite to do so, given the current economic climate. I don't think that, you know, the government's going to particularly care about, you know, what to do about people who are made redundant, who come under the skilled workers scheme, or about those who are working on a part-time basis and the possible discrimination issues that can cause. But I would say that there are a lot of commercial considerations for employers, and that, you know, in a sense that, you know, we can sort of help them navigate through those considerations, and I think really add a lot of value to overburdened HR departments that are going through a lot of restructure. We're seeing a lot of HR, you know, quite senior people suddenly leaving companies because of them making sort of cuts to costs. But at least we can sort of help our clients get through this, and be prepared as much as they possibly can for the end of the transition period. Thank you.
Thank you, Natasha, for setting out the potential issues and problems so clearly. If I can now turn to our final speaker, before we then turn to the questions at the end, Parosha Chandran.
Good morning. Thank you for inviting me to join this panel along with fellow experts. I thought it'd be important to contribute something in terms of the potential ramifications, implications of Brexit on cases involving trafficking and modern day slavery. It's funny that if we reverse time back to 2003, when the sexual exploitation criminal offence entered into force under the 2003 legislation, and then in 2004, the immigration legislation involving all forms of exploitation being criminalised in terms of human trafficking. This was a long time before the Council of Europe Convention entered into force in 2009, and yet myself and others were bringing litigation continuously to establish rights for victims. When I think now about the potential implications of the restrictions on free movement, I feel that we're going to be going back in time, and it's going to be important for practitioners to be litigating in order to establish rights yet again. The main areas that I'd like to just focus on this morning in the 10 minutes that I have are the limits on cross-border information sharing and criminal investigations, weaknesses in safeguarding victims' rights, the immigration system, and how this is going to expose massive potential for trafficking and slavery into and within the UK. Also to look at the case of children and the fact that, in fact, we'll be getting left behind by Europe, which is developing a lot of protocols and systems on cyber trafficking, for example, and protecting, in particular, children from online sexual exploitation. And what about transparency in supply chains provisions, where we're relying on understanding and mapping supply chains that will go through other European countries all the way to the source. So what I thought would be important, though, to raise right from the beginning is the fact that the removal of any reliance on the EU Trafficking Directive 2011 36 EU as a treaty comes with great disappointment. However, we are not leaving the Council of Europe system, and this means that there will be even greater prominence on relying and asserting convention rights under the ECHR in our trafficking cases in court, with a view to being able to adequately articulate arguments relating to positive obligations on the state when it comes to the protection of victims. And ultimately, if we aren't successful in the UK in being able to secure rights, then the cases would be deemed appropriate for Strasbourg, because we will have exhausted domestic remedies by raising litigation points under Article 4 in particular, ECHR here at first instance. I've got a case actually that's in Strasbourg at the moment. I lodged this a long time ago in 2012. This was the first non-punishment case that I sought to raise that related to the drugs conviction of a Vietnamese minor. So that case failed in the UK court. It was the case of R and N. And in that case, despite a conclusive decision that he'd been trafficked, the Court of Appeal decided to apply Article 26 of the Council of Europe Trafficking Convention, which talks about non-punishment, and said that that could be limited to enabling a successful appeal against sentence, i.e. that the punishment should be lifted rather than the freedom from conviction. And so I had lodged that in Strasbourg as a complaint against the UK government for its misinterpretation of Article 26 of the Council of Europe Convention, which should have entitled the child to have had his criminal conviction quashed. The next year, many of you will know, I brought the case of R and L and others, where I directly relied upon Article 8 of the EU Trafficking Directive, which was much more explicit in being called non-prosecution and non-punishment. That case succeeded and changed law and policy. So the reason why I raise this is that when we come out of the EU without reliance on Article 8 of the EU directive, namely the wording of the non-punishment provision to prevent against prosecution and punishment, we'll be left with the wording of the Article 26 Council of Europe Convention definition on non-punishment. So therefore that case in Strasbourg is very important, because it being the leading case in the Council of Europe system on non-punishment, it will confirm what non-punishment means. Does it apply to criminal liability as well as to sentencing? What are the restrictions, if any, on the application of forced labour on the case of a child? And does a child, for example, have to be exploited for a certain length of time before they fall susceptible to being entitled to forced labour and identification? So that's one thing. The other thing that we're going to have to do in the future when we're looking at cases is relying a lot on UN guidance, on guidance from the OSCE. UK is a member of the OSCE and of course is ratifying a state party to the Palermo Protocol. So the guidance on law and policy that has emanated from the UNODC in particular, but also strategically from the very progressive work of the UN Special Rapporteurs on trafficking against persons, will also be suitable for very close scrutiny. Also the Special Rapporteurs on child labour and the other forms of exploitation under the UN system. The shame is that we have been able to lead to a great extent some of very important joint investigation teams when it comes to the sharing of criminal intelligence, because of course in a lot of cases, particularly when it's come to EU nationals such as Bulgarians and Romanians and Hungarians, there's been a great deal of identification of traffic victims in the UK, and this has been able to secure joint investigation teams across borders to bring these trafficking networks to a halt and to enable the prosecution, conviction and imprisonment of those responsible for what were burgeoning trades. Unfortunately, we are coming out of, therefore, this camaraderie, this important intelligence sharing network. And so Britain will have to sign memorandums individually with different EU member states in order to enable these types of investigations to continue or be initiated in the future. But again, it means that a lot of information sharing by those who are our closest neighbours may be lost on us and will be the last man in, just as we were the first man out of the EU, which will again highlight the vulnerabilities of those who are no longer able to be protected under policing at its highest sophisticated level. It reminds me of a case in 2008 that I brought, the case of Patience Asuko, where I sued the Chief Commissioner of the Metropolitan Police for failing to investigate trafficking. It was 2 years before the Rantsev case in Strasbourg, and I succeeded in having the Chief Commissioner disband his human trafficking team, which at that time had been focused on sexual exploitation. He then rebranded it, reformed it, retrained the police on forced labour and servitude. And we're really going to need a lot more training as time goes on, both of the police, of border officials, of everybody whose work encompasses or crosses into modern slavery issues, so that victims of trafficking and modern day slavery are recognised with increasing prominence, when the system, which is to restrict immigration, will only have one outcome that is predictable when it comes to slavery and servitude, and that is to increase it. It's globally recognised that in restricting routes to migration, restricting legal, lawful routes to migration, plays into the hands of those who want to exploit both migration channels and the human beings who put their trust in the hands of those to take them from A to B, and at the final destination, there they become lost. So if we look at the ILO forced labour indicators, we can see that each one of them is likely to become much more intense and should therefore need much better care when identifying victims of slavery and trafficking as time goes on, such as abuse of vulnerability. Now, this is something that is straightforward, and yet it's often misunderstood. If somebody comes into a country through an illegal or irregular migration route, they are immediately in a position of vulnerability, which can be taken advantage of by traffickers. But if you look at all of the other means by which a person is trafficked, such as deception, coercion, threats, abduction, one can see that these are the direct means, and the more subtle means, such as abuse of a position of vulnerability, are often overlooked. And that means that victims can be misidentified as illegal migrants, irregular persons in a state, and the attention of those in law enforcement can wrongly and discriminately fall on seeking to declare them as such, rather than on seeking to investigate the exploitation that a person might have been subjected to. In fact, reports have shown that in the last year, when Brexit has been creeping upon us, EU nationals have been, in some cases, willing to remain in exploitative conditions in the UK so as to maintain their opportunity to be able to work at all. And their fear of coming forward will only be intensely highlighted when the borders fall down and shut them in or shut them out. So this kind of understanding as to how trafficking and slavery is perpetuated by traffickers abusing people's position of vulnerability is key. Deception is another ILO feature. We'll often find that increasing as well when regular migration routes are curtailed. Restriction of movement is obvious. It's interesting, actually, if you look at the Council of Europe Convention, Article 5 of the Trafficking Convention talks about prevention and talks about there being the need for regular migration routes. So that might be something to look at when one is considering litigating in the future. Intimidation of threats, threats of denunciation to the authorities. These are the kind of things that we used to see all the time back in 2003 to 2009, when trafficking had no formal status in terms of treaty obligations directly before the Council of Europe Convention came in. Debt bondage we see increasing in the UK and elsewhere, and we'll see it increasing again. Abusive working and living conditions. What we've had is a very sophisticated employment law system that has been able to identify cases of exploitation that might fall short of the criminal standard. Well, what will happen to those standards when we move away from EU directives and the recognition of those types of standards and the breach of those standards being reflective of exploitation in the workforce? So these are some things I wanted to raise for your attention. The case of children, again, is one that is of grave concern when it comes to technological advances in Europe that can start to uncover or are at the start of uncovering very serious networks. Thank you very much for offering me the opportunity to speak about these things today.